first case before us is State versus Belton. It looks like we only have the appellant arguing today. You will have 15 minutes for your argument. The argument is being recorded. Please introduce yourself, keep your voice up, and remain behind the podium. You should not use names of children, minors, and victims during your argument. We have read your briefs and are ready to proceed when you are.
Good morning, Mayor. May it please report. I am Alan Medvick. I am here representing the appellant, Lady Belton. We have raised one assignment of error that the trial court erred in imposing a maximum sentence upon Mr. Belton at the time of sentencing in this matter. I think as indicated in the briefs, my client was one of 4 co-defendants in this matter. My client agreed to a plea entry, a reduced plea agreement in exchange for testimony at the trial of the primary assailant and shooter in this matter. Did testify at that trial in support of what was eventually a murder conviction for that shooter. After the trial, all 4 of the co-defendants were tried at sentencing in one collective sentencing hearing, and it is our argument that at that time the judge imposed the maximum sentence available to Mr. Belton and did so based on evidence that was not on considerations that were not within the record and based on her own independent inquiry and her experience of having been the jury trial judge at the time of Mr. Jones's trial. And it is in that consideration there, just to touch on as an aside briefly, there's some consideration that the judge stated that my client had received a benefit already by accepting a guilty plea to a reduced sentence. That's echoing the statement that the prosecutor made about the victim's position on the matter. That's a perfectly reasonable position for a victim's family to take. As a judge, as judges here, as a lawyer, I think we all know that there are many other considerations that went into that. It was not a reward for pleading. That is based on an assumption of finding guilt at the level of murder, which is not in the record, not supported in any way. And those considerations for reduction based on, as indicated in the record, considerations for offering the plea deal to Mr. Belton and the other co-defendants in the first place, considerations on the state's part as to whether they could even support a finding of guilt at the level of murder, whether they could have found guilty any of these parties without that testimony, to suggest that my client received a sole benefit and that was an outcome I think is little. I believe the word I use in my brief is facile, and I would stand by that. Again, and as you go through this and you go through you have the full transcript of all 4 of the sentencing considerations that went on in this matter. And you'll see that the judge very clearly references her own interpretations of the trial evidence, of the videos that were presented at Mr. Jones's trial, of her consideration over whether Mr. Belton or the other co-defendants testified in a truthful and reliable manner, all of which are not issues in the record of Mr. Belton. In fact, one of the considerations that would go into a plea agreement is the fact, and as any of us who have been in trial positions would know, that one of those considerations, one of those statements is that you want to make sure that evidence that could sway a judge at a time of sentencing is not necessarily presented to a jury. And to have Mr. Belton take advantage of that plea opportunity and then still lose that opportunity to protect his record in light of that sentencing consideration is I think, error. And I would contend a plain error that I think that while I have not articulated the plain error argument and stated that in my brief, I think that is what we are dealing with here at any level. I do think that even on review, that based on the law and what can be considered, the fact that the judge went outside of the record is improper. I think that's been stated in this court, not in this sentencing context, but as recently as the Javion Rankin's case. This court, I believe the two of you were on that panel, cited to the bailiff case, stating specifically that you could not go beyond the record to consider evidence outside the record to conduct its own investigation. That is what happened here. And that law, having looked at the bailiff case, is 80 years old. It comes from a Maddox case from 1966, and I apologize, I don't have that citation right in front of me. And I would tell you that the prosecutor's own citation, own authority, weighs against finding in favor of the state of upholding this sentence. He cites the Brunson case, and specifically the paragraph states that this court cannot modify or vacate a sentence based on its view that the sentence is not supported by the record, which is where Mr. Raley would have you stop in his review. However, the court goes on, the appellate court is not prohibited from reviewing a sentence when the claim is that the sentence was improperly imposed based upon impermissible considerations. And that is what we are saying here, is that she reached this verdict by impermissible means, and the trial judge imposed a maximum sentence based upon her own investigation and evidence outside of the record contrary to law. As I said in the brief, I understand why this sentencing hearing was conducted in this manner, that it would be a long and arduous and painful process for all parties involved to have done 4 different sentencing hearings and to present the same information. I recognize that, but given that consideration, it's the judge's responsibility to make sure that she didn't do exactly what she did and merge those considerations across from one co-defendant to the other, especially when one of them went to trial and the others did not, and in fact testified against that person at trial. I think that this maximum sentence was based on considerations outside of the record and was improper. Mr. Raley again cites to standard language that this court has to presume regularity in the holdings, and that is true in the absence of a record. But you don't have to pretend that there is regularity when the record is clear on its face and the transcripts are clear that the judge went beyond her authority in investigating this case and imposing the sentence. And beyond that, I would stand on my briefs if this court has no questions. Thank you very much for your time today.
Thank you. The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released. The opinions are also posted on the Ohio Supreme Court website. Thank you again.
Thank you very much.